Hey, Ms. Brenda, I believe we're live. You may proceed.
Thanks. Good morning, everyone. This is the New York City Board of Standards and Appeals public review session for March 11th, 2024. Please note there is no testimony permitted during the review session. We will begin with postponements. Item number 1, calendar number 2023-29A, 2372 East 23rd Street, Brooklyn. Deferrals. Item number 2, calendar number 2023-14A, 1707 Richmond Terrace, Staten Island. Decision items. Item number 3, calendar number 360-49BZ, 6905 Elliott Avenue, Queens.
No submission was required for this application.
Chair, we can't hear you on the recording.
Can you hear me now?
Is your microphone on?
Yep, it is on. Can you hear me now?
It's low.
Very low.
Can you turn up the mixer? Am I low? Is it coming through low or is it the mixer?
Just give me 1 second.
Can you hear me now?
We can hear you, but it's just very low.
Because it's on. Am I low too, or is it just the chair? Oh, you're low too.
Yeah, you sound the same, Commissioner Yoon.
Hello?
Testing.
I can, Chase, that's clear. I can hear you.
Can you hear me now?
We hear you, it's just low.
Hello?
That's,
Hello?
that's better. That's better.
Okay, all right, thank you again. So no submission was required for this application. It's an extension of time. So I make a motion to approve this extension of time for 2 years from the time of this grant.
Motion to approve, Chair Chanda,
Aye.
Vice Chair Shabeta.
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Yu.
Aye.
This application has been granted. Item number 4, calendar number 234-56BZ, 10-02 Clintonville Street, Queens.
So received revised information and an updated survey. At the last hearing, we did not discuss the proposed hours of operations. The applicant is proposing to change the current condition, which was a Monday through Friday, 5:30 a.m. to 9 p.m. and Saturday and Sunday, 6 a.m. to 6 p.m. to a proposed hour of operation of 5 a.m. to 10 p.m. 7 days of the week. The current use is an auto repair and a gasoline service station, and what is being proposed is a change of converting the auto repair into an accessory convenience store and a gasoline service stores. And I just want to remind everybody the site is in a C22 overlay in an R32 district. So I just want to know if the commissioners have any concerns with regards to the proposed hours that is being, because that was a condition of prior to the commissioners had. Okay, no one has. So in that case, I want to make a motion to approve with the following conditions. That the hours of operation shall be limited to 5 AM to 10 AM, 7 days of the week for the proposed change from an auto repair to an accessory convenience store. And a gasoline service station. That the exterior lighting shall be directed downwards and away from the adjacent residential use and shielded accordingly as needed. Builder's pavement plan shall be submitted and approved prior to restoration and construction of the sidewalk. The sidewalk shall be restored and constructed pursuant to this approved builder's pavement plan prior to obtaining the TCO. And a new certificate of occupancy shall be obtained within 24 months from the time of the start. Motion to approve.
Chair Chanda,
Aye.
Vice Chair Shabeta,
Just a moment, do we have anything about the existing violations? We have a decision.
Vice Chair,
I'm so-
we can't hear you on the recording.
Should we have a condition that the existing violations should be cured?
Yeah, you can add that to the condition that the violation shall be cured prior to obtaining the certificate.
Whoever's speaking in the room.
should we start the vote over?
Thank you. They tried, they were settings, I mean, it's.
There's somebody who might have moved on.
I'm sorry, it was hard to hear you.
Just in the, whatever, trying to the mixer. Sounds good.
Arlo, that's.
Okay, seems like it's done. So I vote aye.
Oh, I just wanted to know if we should start from the chair, like read the 5 again, or if it's okay to just move forward.
So I repeat the.
I'm gonna ask that we take a 5-minute break to figure out the sound. I'm hearing that people on the other end are having trouble hearing.
Yep, and I believe the IT assistant will be coming.
So to the extent that everyone can hear me, we are going to pause on the motion and we will resume in 5 minutes. Mr. Premier, if you could just put up a break screen,
10.
10 minutes, please.
Just then, yeah, can you hear me? Yeah, Madam Chair, can you try again?
Hello,
Yes, I can hear the chair.
Yeah, how about me?
This is Vice Chair Shabeta, correct? It's just low.
That's low. So I can speak like this, would that be enough?
you literally have to lean into the mic. Shift over so that.
Seems like a fishbowl.
Much,
Right.
much.
Tracy just said it sounds like fishbowl,
Fishbowl.
What's a fishbowl?
It sounds like you're.
kind of echoey.
Can you hear me?
Yes, I can.
How about now?
That's worse, actually, Vice Chair.
Better?
Not really.
Yes. Is it still
This
fishbowl?
is right now is a lot better.
Yeah, is it still muffled?
I can
The
speak
last
this loud
time-
if that would be
This
helpful.
is a lot better, Vice Chair.
I don't know if they hear me though.
Oh, that worked.
No
What
one's
just
answering.
That
happened?
was good. That's
That's
good.
it.
What about now?
Yes.
Carla, you're clear.
Ms. Prenga, can you hear me?
I can hear you very well. I just
I
heard,
can't hear you, Ms. Prenga.
Yeah, how about this? Is that good?
Oh, you're good.
Yes.
Yeah, I
Vice
think
Chair,
everyone's
Commissioner
better
carrying.
now.
Commissioner Sheta
Chris?
sounds really clear.
Hello,
wait, can anyone hear
Jella, we
me?
can't hear you talking.
I can hear Jella. I can hear Jella.
Yeah.
Can you hear me?
Yes. Can
Uh-oh.
you hear me?
I can hear Tracy.
I don't think they can hear us.
Uh,
Oh, you're blurry, Jella.
I've been trying to unblur myself.
Can't hear you, Miss Prenga.
I didn't do anything. I didn't change it, the settings. Can you hear me now?
Yes.
Okay, thanks.
Ms. Prenga, say something?
Hello?
Say something now?
Good morning.
Okay, thank you.
You figured it out?
Ms. Prenga, can you hear me clearly?
Yes.
Madam Chair, can you just say something?
Hello?
Yes. Carla,
Great.
can you hear me?
Yes.
Yes, everyone is much, much clearer. It's much better now.
Okay, so shall we give it a go again?
Sure.
Let's just recall the last item. Has
Okay,
it been 10 minutes?
1 second. Everyone, thank you so much. I apologize for the inconvenience. We're about to resume. Thank you.
Morning. Good morning, everyone. We will resume the review session for the New York City Board of Standards and Appeals. We were discussing item number 4, calendar number 234-56 BZ, 1002 Clintonville Street, Queens. There was a motion to grant. Would you like to?
Let me actually restate the condition. Actually, let me go through my notes again, just to make sure everybody heard it. So we did receive an updated survey and revised plan. At the last hearing, we did not discuss the proposed hours of operation. Prior conditions were Mondays through Friday, 5:30 a.m. to 9 p.m. and Saturday, Sunday, 6 a.m. to 6 p.m. The proposed change is 5 a.m. to 10 p.m. 7 days of the week. Please note that the current use is an auto repair and a gasoline service station, and the proposed use would be a gasoline service station with an accessory convenience store.
Yeah, so.
And the site is in a C22 overlay in an R32 zoning district. So I just want to make sure commissioners are aware of that proposed change in the hours of operations, and everybody's nodding in agreement. You're okay with that change? Yes, Commissioner Sheta.
Just want to clarify, the hour of operations are like specific to the convenience store. The gas station is 24/7, right?
I think it said gas sales and store.
Gas
So
sales
this is
and
applicable
storage,
to both?
both.
Okay,
That's my
Okay.
understanding.
Yep. Okay.
So, and also at the last hearing, the applicant had represented that all violations related to this site were cured. So with that, I want to make a motion with the following conditions: that the hours of operations shall be limited to 5 a.m. to 10 p.m. 7 days of the week for the proposed change from auto repair to an accessory convenience store and a gasoline service station. And that the exterior lighting shall be directed downwards and away from adjacent residential uses, and shielding shall be installed as and when needed. A builder's pavement plan shall be submitted and approved prior to restoration and construction of the sidewalks, and that the sidewalk shall be restored pursuant to this approved builder's pavement plan prior to obtaining a certificate, TCO. And a new certificate of occupancy shall be obtained within 24 months from the time of this grant. So I make a motion to approve.
Chair Chanda,
Aye.
Vice Chair Shabeta,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Yu.
Aye.
This application has been granted. Item number 5. Calendar number 528-71BZ, 133-40, 150th Street, AKA 149-13 North Conduit Avenue, Queens.
Okay, no submission was required. This is an extension of time. So I make a motion to approve this extension of time for a 2-year period from the date of the expiry, which is April 22, 2024. Motion to grant?
Chair Chanda,
Aye.
Vice Chair Shabeta,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Yu.
Aye.
This application has been granted. Item number 6, calendar number 85-99BZ, 1106 Metcalf Avenue, the Bronx.
Okay, so we need to reopen based on a recent site visit. Photos were provided of the site condition, and it is overrun with food trucks, not only on the site, but also on the sidewalk. As you may recall, Community Board had expressed concern in its deliberation that they did see unlicensed vehicles operating on the sidewalks, and there were excess vehicles parked on the sidewalk. So we need to reopen this. So motion to reopen?
Chair Chanda,
Aye.
Vice Chair Shabeta,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Yu.
Aye.
Should we discuss anything right now?
No.
Okay.
I mean, if you'd like to discuss reasons for reopening and instruction to get the applicant, but the applicant's not going to be able to participate.
Right, so we are going to schedule this for a public hearing for another day because the public needs to be notified. But I think the concern here, and if you may recall from the history of this, last year, when it was last granted, board had expressed concerns about the way the site was being maintained, and it was only given an extension of term for 5 years because we felt that we wanted to make sure that the applicant was meeting all the conditions. While it did meet most of the conditions, it seems to have continued to fail on some of the other aspects. And sidewalk, vehicles parked on the sidewalk, even though it may not be their vehicles, the fact that that's happening and they're not able to manage that, that's a concern. And also there are vehicles that are parked inside. Now, if that is being parked, it's a one-off photos condition or something, I don't know. But if it's something that is happening, a business is operating from the site where these food trucks are located there and it's serving a different function than what the board allowed the use to be on this site, it is in complete violation of what the board had granted. So the applicant needs to correct everything and at the public hearing needs to make a clear reasoning as to why, what happened and how it is going to be corrected. And what are they, and it should be corrected now, even before the public hearing, it should be corrected. And we need an operational plan as to how this is going to be addressed going forward. And at this point, I'm not very comfortable giving it a very long-term grant. I would probably, unfortunately, because of the way this operation has been conducted in the past, we may have to give it just another 5-year term because there seems to be a miss in the way the operator is using this site. Vice Chair Shibata,
I agree with you entirely. I have nothing further to add.
Commissioner Otley Brown.
I just want to add that I think this problem is systemic because I just want to remind the board that when this first came to hearing this go around, there was evidence that they were using their side yards or their front yards, because it's a corner lot, as storage for recycling. And the applicant's rep admitted that they were allowing a company to store huge amounts of recycling in their front yards. And so we had to tell them to cease and desist with that, and then to drive by a month or two later and now see that, okay, that's been discontinued, but now they're allowing a different type of storage on the site, all of which is against what was prescribed by the board, is problematic.
Mm-hmm. Thank you. Commissioner Sheta?
Thank you, Chair. I believe reopening this case is a favor to the applicant, to the owner of this facility. That would send a message that this board closed this case based on a understanding and a conveyance from the applicant that conditions will be fixed and will be fixed forever. But that like going back to what was existing before, parking on the sidewalk and the messy conditions on site is not painting a nice picture about this use, and I caution the applicant to fix these and fix them in good faith and keep them fixed. Otherwise, I believe the consequences are not gonna be like favorable to them. Thank you.
Okay, thank you. Commissioner Yoon?
Thank you. I agree with your statement that we should consider a shorter term if we do consider granting this application in the future, but we need to hear from the applicant at the subsequent public hearing.
Okay,
I have nothing further.
thank you. Okay. Next case, please.
Calendar number 12. Item number 7, calendar number 12-01BZ 2829 Edson Avenue, the Bronx.
Just 1 second. I'm scrolling. First of all, I really want to thank the applicant and their team to chip away at this issue and finally bringing it to a point where we believe the sidewalk will be built as per DOB approved set of plans. And it was a good learning experience for us to see the process, to understand how the DOT SCARA process and what it entails, it requires. So I do appreciate the applicant's willingness to go through the process, and the community board was very appreciative and is eagerly waiting for the sidewalk to be built. So all said and done, I think the additional information the applicant has provided has been very helpful, and it clarifies the timeline of deliverables and construction. So and the applicant is proposing a 20-year term. I'm satisfied with that. The reason being that this sidewalk construction is quite an intense set of construction. So given the nature of the business, I think 10-year may not be sufficient, 20-year in this case. And this particular operator has maintained its site pretty well throughout and throughout the discussion. As we were asking for changes within the site, the applicant did take all necessary steps to address them. So I'm very satisfied with the applicant's response, the operator's response. So I am satisfied with the 20-year term. Commissioners, do you have any concerns with that?
I just have one request, that they give us some notification as to when that construction is completed, so that they don't fly backwards.
Okay. Okay. So I am then going to make a motion to approve a term of 20 years from the last expiry date to July 17th, 2041, and amend an amendment to legalize the alteration to a previously approved PSA plan with the following conditions. That the improvements to the sidewalk fronting Grace Avenue shall be built to DOT approved standards and approved by appropriate agencies. The applicant should give notification to BSA when the sidewalk construction is complete. And the sidewalk improvements shall be completed and approved within 12 months from the time of this grant. Is that satisfactory? Okay. So with that, make a motion to grant.
Chair Chanda,
Aye.
Vice Chair Shabeta,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Yu.
Aye.
This application has been granted. Item number 8, calendar number 1301 BZ 2875 Edson Avenue, the Bronx.
Okay. Again, another part of this parcel. My conditions are as follows. This is again to extend the term for 20 years. So I make a motion to approve the extension of term for 20 years from the last expiry date to July 17th, 2041, and amendment to legalize alteration to a previously approved BSA plan with conditions that improvements to the sidewalk fronting Grace Avenue shall be built to DOT approved standards and approved by appropriate agencies. The applicant should give notification to the board when construction is completed, and the sidewalk improvements shall be completed and approved within 12 months from the time of the grant. With that, motion to approve.
Chair Chanda,
Aye.
Vice Chair Shabeta,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Yu.
Aye.
This application has been granted. Item number 9, calendar number 143-07 BZ 6404 Strickland Avenue, Brooklyn.
Okay. So this is an extension of time. So I make a motion to approve this extension of time for 4 years from the date of the grant, so that will extend, I believe, to March 11, 2028. Motion to grant.
Vice Chair Chanda,
Aye.
Vice Chair Shabeta,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Yu.
Aye.
This application has been granted. Item number 10, calendar number 2021-56 BZ 337 through 349 and 351 through 357, 39th Street, Brooklyn.
Okay, we need to defer this to, we will not defer it, we'll second call it for tomorrow because we are still waiting for the final sign off. We did receive a draft, but we need the final sign off.
Okay, noted. Thank you. Second call for that.
It will be the first item that will be heard tomorrow.
Sure. Thanks. Item number 11, calendar number 2022-69A through 2022-75A, 2001 Bartow Avenue, AKA 500 Baychester Avenue, the Bronx.
Okay. So this is an application for a revocation of permit with reference to 7 signs for advertising sign that are in violation of zoning resolution section 32-662, which prohibits advertisement signs within 200 feet of an arterial highway. So based on the evidence provided by Department of Buildings and City Planning, I believe DOB's approach was rational in applying zoning resolution section 32-662 to determine the distance of the signs from the arterial highway. So I think the motion is to deny the revocation, right? That's kind of how I have to word it.
Madam Chair, it's a motion to approve, but then the board will.
It's a motion to approve the
Appeal, the appeal, which we would vote
We can vote.
no
yes, sir.
to if we didn't agree with the appeal.
Motion to approve.
Motion, it's a motion to approve, so not to deny.
Motion to grant the appeal.
Okay, all right.
But you
So it's
don't-
so the motion is to motion to approve the appeal to
Grant the appeal.
grant the appeal.
And then the question is yes or no.
Oh, that's right. I actually do want each one of you to weigh in on your reasonings for your determination. Vice Chair Shibata.
Thank you, Chair. I was not compelled by the appellant's argument of collateral estoppel as the distance of the arterial highway was never a factor raised in any prior litigation. The two prior actions before us were Bartow 1 and Bartow 2, which dealt with two very distinct questions that are independent from the issue at hand. Further, I find that the 1947 alteration map, the DOB's reliance on the 1947 alteration map and momentum map are properly relied on. And I have nothing further to say on this.
Okay, thank you. Commissioner Otley Brown?
I agree with the statements that both the chair and the vice chair have stated. And I feel that the DCP letter that was sent in the last submission was very crucial to me in helping to form my opinion, because as the authority charged with interpreting the city map, they clarified the meanings of the alteration maps and why they were important, and why especially the 1948 alteration map that was adopted by the Board of Estimate in 1959 was crucial in showing the dissolution of Baychester Avenue as its own discrete street and its incorporation into the New England Thruway. And so after that, I felt that DOB had properly relied on that map in making its determination.
Thank you. Commissioner Shetta?
Thank you, Chair. For me, although the letter from the DCP was very decisive, since the DCP is acts like the custodian of all alteration maps, and they provided very clear cut explanation indicating that the site is abutting directly the highway, the New England Thruway. In addition to that, I did look at the applicant submission, and I saw that the applicant put before us two main arguments. The first one is that DOB had the opinion before us on previous matters that the distance is less than 200 feet. When I looked at the previous matters and the submissions made back then, it is very clear that the distance never been a subject of a dispute before the BSA. All what was before BSA before, whether like a group of signs constituted a group of a small signs, I would say, constituted one big sign. And I believe that was before BSA. Previously, the distance was never before us. So the second thing, even looking at Google Maps and looking at the description of the thoroughway on the submissions from the DCP, it's very clear that the description of the throughway is much more than 200 feet. If we go with the applicant explanation that the roadways are the only portion of the thoroughway that's meant to constitute that thoroughway, I believe this is in clear contradiction with the explanations from DCP. So I do believe at the end that DOB did a very good job explaining and proving their case, and I am not buying the argument from the applicant, so I will vote no.
So you basically you're saying DOB did provide ample evidence to clarify the actual distance between the arterial and the subject site?
Yes.
And it was applied?
And they were multiple, not just once.
All right, thank you. Commissioner Yoon?
Thank you. I agree with what's been stated. prior to reopening the case on November 13th of 2023, I agreed with the Department of City Planning letter that stated that Baychester Avenue is part of the New England Thruway and that the western boundary of the subject site is coincident with the eastern boundary of the New England Thruway. The appellant's submission of new evidence in November of 2023 did not change my mind. The purpose of the condemnation maps is not to define the extent of a street or a thruway. As such, I believe Baychester Avenue is part of the New England Thruway, that the signs in question are therefore non-compliant and that the appeal should be denied.
Thank you. All right.
To accept.
Okay,
Motion to grant, right?
yeah, so we need to take a vote now. Motion to grant.
Chair Chanda,
No?
Vice Chair Shabeta,
No.
Commissioner Otley Brown,
No.
Commissioner Sheta,
No.
Commissioner Yoon.
No.
This application has been denied. Calendar number item number 12, calendar number 2019-264BZ, 3568 Nostrand Avenue, Brooklyn. This needs to be deferred due
Yes.
to open seeker. All right, item number 13. Calendar number 2020-51BZ, 2020-52A, 2020-53BZ, 2020-54A. 95 and 105 Ridgeway Avenue, Staten Island. This also needs to be deferred due to open seeker. Calendar, item number 14, calendar number 2021-17-BZ, 87-19 Rockaway Boulevard, Queens.
Okay, so we received a revised set of plans, statement of facts, which unfortunately reverts most of the design changes the board had asked the applicant to do, had the applicant to consider, and the applicant had revised those plans, I believe, at least at the last August hearing, last year's August. So, and subsequently, the board was mostly fine-tuning the plans based on certain features that were being implemented, including landscaping. So, so this change is very much back to where we had started the hearing from, apart from some improvements that have happened, including the landscaping. Because of that, we need to reopen, because this is, again, we need to go back and revisit why it needs to revert back to the original plan. And the applicant in its letter states that because of some of the operational reasons, they're reverting back. But, since August of last year, the applicant should have had all the opportunity to clarify why. And that wasn't done. So we need to reschedule it for a public hearing. And at that time, the applicant should clarify its reason to revert back. I would though note that the planting bed as built and the photographs shown do not correspond with the plan detail that is shown in the plan set BSA 10. The curb detail as shown on the plan shows a planting bed that is an in-ground planting. But what has been built seems to be raised above ground by at least 1.5 feet. And it's, I hope it thrives. We always ask for in-ground because chances of plants thriving is better. But if somebody is proposing an above grade planting, then you need to make sure the planting can, plants can survive in that raised platform. And you need to have appropriate set of plants that can survive in that shallow depth, and also how you irrigate it and take care of it. So those need to be addressed. The applicant is also proposing to retain the 88th Street curb cut to allow for the fuel truck. And again, this goes back to the discussion back in August, where the applicant did show maneuverability plan where the 2 curb cuts on Rockaway was going to be used by the fuel tank to approach the site. I believe the applicant is listening, so please take note of this when the application is being rescheduled for hearing. Come prepared with the reasons as to why the drawing needs to be revised. And if you need the operator to kind of help us understand the reasons, please do bring the operator also to represent the case. Any comments from the commissioners, Vice Chair Shabeta,
Nothing further from me.
Commissioner Otley Brown?
I just want to say, this is not the first time that we've had a case where an applicant has made a change after the board has already come to an agreement with the applicant as to how they want a site laid out, and it really shouldn't happen. It just ends up adding a lot of processing time for the applicant and for the property owner, which of course leads to inflated costs. Once we make a decision and we have a plan, that plan should be followed. And if not, if there does have to be a change made, the board should be alerted that ahead of time that there's going to be a change and a reason why should be given. It shouldn't just be slid in under the rug right before decision in the hope that we're not looking carefully at it. That really is problematic.
I agree. Well said, Commissioner Otley Brown. Commissioner Shetta.
Thank you, Chair. Nothing further to add.
Okay. Commissioner Yoon?
I have nothing further to add.
Okay, thank you.
So we did not actually vote to reopen, so would you like to?
Huh?
Vote to reopen.
Oh, yes, we did. We have to.
Yeah, okay, based on the discussion. Yeah, sounds, okay, so can you, I think you have to go off the motion maybe.
My apologies. I thought I did say motion to reopen and we did take the vote on it. So my apologies.
That's okay. Chair Chanda,
Aye.
Vice Chair Shabeta,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Shetta,
Aye.
Commissioner Yoon.
Aye.
So this has been reopened and it'll be scheduled for a later date
Yes.
based on the discussion at the review session.
Yeah.
Calendar number 15, or item number 15, calendar number 2023-61-BZ, 1865 Ocean Parkway, Brooklyn.
The applicant did provide a revised rear yard study map, and the statement of fact also has been revised to clearly state the rear yard depths on the first and second floor. So appreciate the applicant making these submissions. So I make a motion to approve with conditions that a condition that the removal of exterior walls and or joist in excess of those indicated on the BSA approved plan shall void the special permit. Motion to grant.
Chair Chanda,
Aye.
Vice Chair Shabeta,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Shetta,
Aye.
Commissioner Yoon.
Aye.
This application has been granted. Appeals calendar, continued hearings. Item number 16, calendar number 2023-43A. 638 East 11th Street, Manhattan. I wanted to raise something here. I think you will be discussing item number 17 first, right? So, I guess item number 16 to be discussed at a later date.
Yes.
Okay. And then item number 17, calendar number 2022-44A, 638 East 11th Street, Manhattan. This is the appeal to a DOB determination.
Wow, it's that sensitive.
And just remind the public that we're still in a review session. Once we call the public hearing, we'll invite the public to participate.
Okay, so we did receive submissions from both DOB and representative from Sky East. There were follow-up response on these. So I want to thank both the both teams for providing their response. Based on the information provided, DOB's response is very thorough and very clear. It responded to all the questions that were raised and chronologically laid out the timelines of permits filed, certificate of occupancy issued, applicable regulations, laws, and construction codes, and at the time that were applicable. And the narrative also clarified why and when an Appendix G would be applicable regardless of when the job was filed. So I found the submission very, very informative. And in addition to the initial submission and associated with the follow-up submissions, I think it really cleared the picture. And yes, it is a little bit of a, there are various pieces and they may not all fit perfectly. They are, but this letter really clearly lays out how all the various aspects that goes into reviewing and approving a permit or a violation, how they line up. However, the narrative provided by the representative from for Sky East did not add any new information, for me at least. Sky East's 122 submission, January 22nd submission, states there were a lot of information that I thought was falsely represented or misrepresented. It states, like the January 22nd letter states, that the DOB had a limited scope in curing the objections related to the front building, and that, quote, administrative actions were undertaken by DOB that ultimately resulted in DOB violating the BSA revised resolutions issued on July 17, 2018, resolving Appeals 166-12A and 107-13A, unquote. I don't want to sound repetitive, but a board made its position very clear on this matter at the last hearing, and board's resolution had directed the appellant to bring the building into compliance and cure the objection and address all the violations. Furthermore, board's resolution did not limit DOB's enforcement authority. On the contrary, it recognized DOB's enforcement authority and stated, quote, nothing in the resolution shall be deemed to stop DOB from enforcing against the subject site as DOB may deem necessary, unquote. This is not an exclusive statement. Also, based on the chronology of the filing and changes to firm map and flood regulations, Appendix G is applicable when there is a change in occupancy from a non-habitable space to a habitable space because it increases the degree of non-compliance. DOB made a statement in its January 17th submission stating that Sky East applied in 2011 to alter the use. And at that time, 2014 code was not there, and exception 15 regarding Appendix G was not in effect. And it was making an assumptive kind of statement, and it said that if Sky East had obtained a permit before exception 15, design flood elevation went into effect, it would not have been applicable. Now, Sky East representative in its submission of Jan 22nd applied this to justify that since the board confirmed 2008 CO as legally issued permit, then the site meets the definition of pre-firm development, and since the site was at that time, 2008, was located in Zone B prior to 2014 pre-firm. I want to clear, and I want DOB to confirm that at the public hearing, that DOB made this statement in reference to the 2011 alt map job, alt 1, job number 120692642, which was to convert a community facility use to residential use. And this was a hypothetical scenario DOB made, assuming only if, highlighted, bold, everything, if the building had been in full compliance, then such a path may have been possible. DOB's February 14th letter added more clarity to this. It stated that, quote, "The 2014 changes to the flood zone had no bearing on whether the department correctly issued the permit in 2004. And since Sky East was adhering to the 2008 certificate of occupancy," unquote, the 2008 CO had no residential use in the cellar and first floor, and therefore it wouldn't have applied. So also DOB's exhibit submitted on February 14th of an audit sheet from job number 103703226 from 2015, I thought was very interesting. Not only does it establish that the flood regulation was in effect and DOB did consider it in its review for a change of occupancy to residential use, though the outcome to resolve the objection is disputed by Sky East as represented by DOB in its letter, it is safe to say that Sky East was aware of the applicable flood regulation in 2015. So based on all the submissions that have been made to date, I think DOB has applied the regulations appropriately, and the applicability of flood regulations and the need for a new permit for a change of use, I think those were all very justified, and I don't have any other further questions on it. Vice Chair Shibata.
Thank you, Chair. I believe that DOB's determination was based on the code and facts of this case, and I do agree with your statement that they did a very good job laying out all of the code and simplifying this application. Section G102 of the appendix, it states that this appendix shall apply to alterations or repairs to pre-firm buildings and structures that increase the degree of noncompliance. The conversion of any space below design flood elevation from a non-habitable space into an habitable space shall be deemed an increase in the degree of noncompliance. That, along with the fact that the department must review a permit pursuant to the current construction code, and that's explicitly required in Appendix G. And therefore, I don't find the appellant's argument very compelling, and I do agree with DOB.
Thank you. Commissioner Otley Brown.
I also agree that DOB very clearly articulated its position and the policies, and also the building code, the zoning resolution, and everything it used to arrive at its policy direction. And it seemed like they very clearly and fairly applied those, the resolution and the building code to this case. I don't see anything in the documents that have been presented to point to the fact that DOB might have unfairly targeted this property. So I have, I feel that the Department of Buildings has a very compelling position, and I'm ready to support it.
Okay. Thank you. Commissioner Shetta.
Thank you, Chair. The argument of the applicant, as indicated in the two submissions made to us for this hearing, depended on two main points. The first point was that the claim that the board in its ruling back in 2017 did direct the DOB to resolve the violations, the non-compliances, and he's kind of implying that the board did that and specified a route via amending the 2004 filing after the board ruled that the 2008 CFO is valid. I couldn't see this in the resolution for the board ruling back in 2017. I did read it 2 times and I couldn't see that. If the applicant can guide me to a specific paragraph, sentence, or whatever in the board resolution that says that the board did say to DOB to legalize the non-compliances or fix the non-compliances via an amendment to the 2004 filing, I would be more than happy to look at it and like change my position. The second point, yes, I agree. I believe this is one of the best projects I did work on, DOB wise. The argument was very compelling. The administrative code is very clear and it prevents DOB from amending the 2004 filing simply because it was signed off long time ago before the issue arises. So I do believe that DOB has a very valid argument here that the Appendix G should be applicable to the building as it is today. One more thing, I saw that the applicant is trying, it's not like very clear, but it's kind of like he's approaching this, is trying to like argue that the alterations or the improvements that's gonna be done to the building to change the use from community facility to residential is not a substantial improvement. Although like financially they might be, but the code is very crystal clear. And if you're changing use for a building that's located in a flood zone, putting people to live below design flood elevation, it's done deal. You have to adapt and comply with Appendix G. So I just wanted to raise this, preparing for the case before this one, the variance case, just to give him heads up. So my position is, yes, I really support DOB argument, and I believe they did an excellent job. Thank you.
Thank you. Commissioner Yoon.
Thank you. I also commend the DOB on its response. It was very helpful and very clear. I agree with you, Chair, that the appellant's response did not provide any new information or clarity in support of their argument. In their submission on January 22nd of this year, as a response to the notice of comments they received prior, in item 14, they assert that the site is currently in a zone X when it's clear on the preliminary form of 2013 that the site is in an AE zone. Therefore, the applicable Appendix G requirements apply. There are some similar kind of typos or sloppiness in the appellant's response that also did not help in clarifying their argument for me. Also, I agree with you, Chair, that the assertion by the appellant that the prior BSA resolution somehow prevents DOB or limits DOB's authority to enforce applicable codes is incorrect. I have nothing further.
Thank you. All right. We then close the review session.
This concludes the public review session for the New York City Board of Standards and Appeals, March 11th. We will commence with the public hearing. How long do you want? Do you want to?
10 minutes. Okay, 10 minutes. I think we only have one case.
11:15.
What time is it now?
11:05.
11:05, 11:15.
And Madam Chair, we will commence with this appeal as the first matter.
Yep, the only one.
Okay.
Thank you.
We'll resume at 11:15.
Okay.
Okay, Ms. Prenga, we are live. We are streaming. You may proceed with public hearing.
Good morning, everyone. This is the New York City Board of Standards and Appeals public hearing for March 11th, 2024. Our application for continued hearings is on the appeals calendar. Item number 16, 2022-43A, 638 East 11th Street, Manhattan, will be adjourned and discussed at a later time. Item number 17, calendar number 2022-44A, 638 East 11th Street, Manhattan. This is the appeal of the DOB determination.
Okay. Do we have? Huh. Why can't I see the participation list?
Yeah, he's.
Oh, he's there. Okay. All right. Okay. Good morning, Mr. Barshaw.
Good morning. If it's okay with everyone, I'd like to start with Commissioner Shetta's question about directing to the appropriate language in the resolution. This is on page 11 of your resolution, where
Could you
it's
just introduce yourself and state your representation?
I'm sorry, should I continue?
Please state your name for the record.
I'm sorry, Stephen Barshaw, Stephen S. Barshaw Law PLLC, representing the applicant.
Proceed, Barshaw.
So on page 11 of the resolution, it directs as follows. It says that the applicant shall submit to the Department of Buildings plans sufficient to bring the front building and rear structure located on the subject site into full compliance with inter alia, the zoning resolution and the building code, and DOB upon finding that the plans cure existing objections. That's the language I want to emphasize, including but not limited to the lack of secondary means of egress from the front building, shall issue permits for all necessary work. The existing objections were quite thoroughly documented before the board. They did not include anything to do with Appendix G. The DOB's own submission provides to you the documentation from 2016. The language that is referenced on those objections, which calls out in writing the reference that someone at DOB made to the flood regulations, was not an enumerated objection. It was never stated as an objection number. It was never represented to this board as being an objection by DOB, and it certainly was not represented to the applicant as an objection. Everything that all of the board members have focused on that DOB is providing now is a revisionist history. None of this was provided to the BSA before. DOB never said any of these things as part of a review that went on for years. DOB cannot now, after the fact, after the resolution, say in essence, this is what we should have done back then.
Okay.
That's what they're saying in all of the submissions that they make to you. They're saying, if we had considered it this way, this is what we would have done. And now we want to do it now. No, the applicant would not have taken the positions that it took before this board during the prior proceedings if it knew that Appendix G was lurking in the background. DOB does.
Mr. Barshaw, I think you're repeating yourself. We get what you're saying. However, I respectfully disagree with you, partly because while the BSA resolution may have stated that language, because the issue at that time was curing the violations, and the curing the violation for the front and the rear building, and not focusing on the change of use. It was curing the violation and bring it back to 2008 regulations. So keeping that as a baseline, the issue of Appendix G did not come up at that for that very reason, because 2008 permit was with regards to the community facility uses that were located on the ground floor and in the cellar of the front building. And that's what the board was asking the applicant to cure. And should, in the process, the applicant not cure it the way the 2008 regulations the 2008 CO stated, and it was going to be something else, then the board in its statement, and I read it out at the hearing, and I've read it out twice throughout this whole proceeding, in the initial hearing and this time, board was never exclusive about limiting DOB's ability to exercise all its rights and all the legal regulatory controls, code regulations, everything applied. If you were to stray from what the 2008 CO allowed, and it were to be done in a different way, then all the regulations as applicable currently or as applicable today would hold. And I don't think in DOB submission, it deviated from the way the regulation directs you. It followed the regulatory norms and procedures accordingly. Commissioner Shetta?
Yeah, I do agree with you, Chair. And I even the language that was just pronounced by the applicant representative, I can see in any like in the plain language even, any direction to DOB to please go grab the 2004 application, amend it, and legalize the existing conditions or clear the violations.
If I may, since this is being recorded, I would like to make my record, if that's okay.
You will have
We don't want to overlap the discussions because it's very difficult to hear it, and transcripting it will be very difficult. So please give Commissioner Shetta a chance to complete his statement, and then I will go to you.
Give me 1 second. I just want to yeah, this is the resolution here, and this is page 10. I did mark this and read it, like I said, like 3 times. And the plain language does not suggest or direct DOB to go and amend the 2004 filing period. This is point 1. Point 2, the claim that the applicant or the owner didn't know about the DOB objection or DOB awareness of the Appendix G non-compliance back in 2017 at the time the board issued the resolution is simply incorrect, because if you look at this submission here from DOB and if you look at the date here, the handwriting, the date is 2015, and it clearly indicates here that flood zone regulations, no filing. So the issue was there, it was known, and it wasn't known. So even if the board indicated that violations as a whole, one of these violations was the non-compliance with Appendix G.
Provided it was going to be a residential use. If it is not going to be residential, then right.
Yes. And this, by the way, these kind of like objections.
But I don't think the board weighed in on the change of use. Board was holding firm to the use that the certificate of occupancy had granted at that time, which was a community facility use.
Because it's not up to the board to weigh in something related or relevant to Appendix G, but for waiving provisions of this appendix. And that was not before the board back in 2017.
Just for the record, I want to state that initially Commissioner Shetta shared excerpt of the resolution from page 11, which says therefore it is resolved, and then he shared the one of the audit page from dated 9/15/15. Okay.
Thank you.
Go ahead, Mr. Barshaw.
Thank you. With great respect to the board, I believe the statements that you are making are internally inconsistent. First of all, the notation that is on the objection sheet that has just been pointed out is not an objection. It is not numbered. It is not listed as an objection. And indeed, all of the correspondence, including the correspondence that was provided by DOB, does not make reference to that as being an objection or one that the applicant needed to satisfy. In fact, as I argue in my submission, this points in the exact opposite direction, that DOB knew about this issue, did not raise it as an objection, and it was never presented as such to this board. This also shows that back in those days, whatever was being proposed by the applicant, and the plans did not change through the time of the resolution, and they did talk about residential use, All of those things did not give rise to an objection regarding Appendix G. And the DOB needs to live with those representations to this board. The applicant has the right to rely on those. And when the DOB was ordered by this board, this board, in my opinion, did not go back and started to fine grain what was proposed or not proposed. What it basically said was, you guys have been through this process. You've been through the audit. You've been through everything that occurred. Now make sure that these plans are the ones that were consistent with the objections being satisfied, which they were, and that therefore permits should be ordered. Now, if this board is going to authorize the DOB after the decisions were made to raise new issues and do something, then my belief, and I'm stating it quite directly, you know this from my submission, my belief is that everyone here was misled. And misled by the DOB saying, oh, all of the objections have been satisfied. Well, obviously they weren't. You can't have it both ways. Can't turn around and say everything was satisfied and then come in after the fact and take the same set of plans and say, no, you've got major problems.
Thank you. I think we are reiterating the same thing over and over again. What I would clearly say, and say it for the last time, and because I really don't think this is helping moving the discussion. In my statement, while the flood regulation note was stated in the audit sheet, whether DOB asked you, notified you, or whether you agreed, I'm giving you the benefit of the doubt that I stated that's disputed how that discussion came to an end. The fact that it was noted, and I would be absolutely amazed that nobody from your team, the architectural team, did not see it and kind of, or blink an eye, or did not think about it, but just kind of said, okay, we didn't discuss it, I didn't agree to it, so I don't need to believe that it exists. The fact that it's there on paper, and fact that whether it was discussed or not, I'll give it a benefit of the doubt. The fact that it was there is good enough of a reason for an expert, for a professional to know that it is an issue that they need to resolve. However, that resolution really has to do with if you're going to legalize the illegal conversion of the community facility use to residential use. The board at no time was asking, and that was not before us. The board was asking it to be reverted back to the 2008 condition. I really do not, I feel like I'm repeating myself, but board at all times said revert back to the 2008 CO. And what that means is reverting back to what the use that was permitted at that time, not the use that was illegally being used for. The legal use as stated in the city certificate of occupancy. I'm just going to state that once and for all. I'm getting tired of repeating myself. Any other questions for Mr. Barshaw? Okay, all right. We have a representative here from DOB. Would you like to speak?
Yes, Madam Chair.
Okay, go ahead. Please identify yourself.
Sure. Hopefully this works with the microphone. My name is James Schmitz. I'm assistant.
Where you bring the microphone down, pull it down, and then. Yeah, there's some weird.
Does this work?
Can
everyone else hear me? Hopefully.
We can hear him on the recording.
Okay, great. I'm James Schmitz. I'm Assistant General Counsel for the Department of Buildings, and I'm appearing on behalf of that agency. I'd like to thank the members of the board, Madam Chair, Vice Chair, and all of the commissioners for presenting me with the litigator's worst nightmare, which is a situation where the tribunal seems to be largely in my favor. And yet I am very, very tempted to speak and show how clever I am by pointing out additional things that may only make the situation worse. So I'm going to resist that temptation. I'm going to largely rest on the record, but I just want to respond to a few things that Mr. Barshaw said. So one of the things that we included in our February 14th submission was a copy of the audit objections. And I noticed that there was this handwritten note at the bottom that referred to flood regulations and and I think there's a hyphen and then there's a new filing. Mr. Barshoff points out very vigorously in his response that we don't know exactly what that was about. We don't know exactly what the understanding was, and that's correct. Unfortunately, I don't have an email trace. Mr. Barshoff, I don't think, was able to locate one either. So I just want to note that the only reason I mentioned that is that the idea was in many of Mr. Barshoff's earlier submissions, the idea was that Sky East was somehow taken by surprise. And I think there's at least some evidence. How much weight the commission wants to give to it is up to you. But I think there's at least some evidence that maybe everybody may have been on notice about this issue at the time. What I do want to respond to, though, is Mr. Barshoff's reading of the revised resolution. And I think there's two things. One, as Madam Chair Shanda pointed out, the question of DOB is under an obligation. They're required under this revised resolution to issue a permit when we receive an application that addresses the existing objections, right? Once we get that application, we must issue that permit. I agree with Mr. Barshoff about that. The question is whether or not we ever received such an application. And I would argue that we haven't because, and I don't have a copy of the audit sheet with me, but I believe that it's at the bottom of the first page and the top of the second page where there's numerous objections about that illegal conversion, right? That's what needs to be cured. And so the idea that curing that illegal conversion by performing the illegal conversion, I don't think that holds up logically. But there's a more important threshold question, which is that, as I discussed several times in my submissions, DOB can't vary the application of Appendix G. We have no authority to do that. Only this board has the authority to vary the application of Appendix G. And the matter that was before the board that began in 2012 and then in 2013 was with the vested rights case, neither of those were variance cases. And I would argue that the board, to take a term from regular legal practice, that the board did not have subject matter jurisdiction to grant a variance in this case. And so whatever those existing objections were or were not, whatever the board may have written in this resolution about an illegal conversion or didn't write about an illegal conversion, my argument would be that there was no jurisdiction to grant that variance. There's no jurisdiction for DOB to act as if a variance had been granted. And ultimately, I think that's really all I have to say, unless the board has any other questions.
Any questions? No, I think you're absolutely right in making it that we did not have the jurisdiction then to weigh in on Appendix G, and the focus was purely to cure the objections related to 2008 certificate of occupancy.
And even if we did, we'd have to say it specifically in that
In that resolution.
There's no, to rely on,
Right.
The enumeration of objections being inclusive and everything else is just open, is now waived because we didn't specify it, I think is a stretch. And I thank you for your statements.
Thank you.
If I may, Madam Chair.
Yes, Mr. Barshoff.
It is not this board that I am saying acted inappropriately. What I am saying is that it was DOB's obligation after it conducted an audit and it represented to this board that all of the objections were satisfied. Had there been, and I really want to make it very clear, that language on the objection sheet is damning for DOB. That language on the objection sheet shows that that issue was raised internally by them. They did not note that as an objection. That is a fact. It is not up subject to interpretation. And because they did not do that, and because the issue came up at that time, at least in their mind, my clients' experts were not under any obligation to reach out to DOB and say, what do your handwritten notes mean? If DOB had an objection, they were perfectly capable, and they certainly went on at length to enumerate every objection conceivable that they could raise. And to turn around and to say or to intimate that my client had an obligation or its consultants had an obligation when we were going through a detailed audit for years to demonstrate compliance, plan review over and over and over again, and to now turn around and say that none of that mattered, that because these notes are there that my client is prejudiced? Absolutely not. I'm sorry. And it is not the fault of this board. It is DOB's. If DOB wanted to raise that issue, it certainly had notice of it. It could have done so. And this board is trying to find ways of retrospectively justifying what DOB did not do. DOB's, they are very experienced. They know what's what. And they turned around and they led my client to believe, and I had these conversations with Andrew Wallace. I'll put it in an affidavit where I said to him, we get through this done, the building permits are going to be issued? The answer was yes. And I withdrew litigation against the city on that basis.
Okay.
No, the bottom line is that no matter how this is interpreted, my client was never put on notice about Appendix G. If anything, the opposite was the case. And the plans always showed legalization the same way before as they did after. If it turned as after this board's resolution, if the DOB felt that those plans needed to be reviewed under Appendix G, everything they put in their submissions now, they should have put into their submissions before DOB came to you and said, yes, it's all been cured. Now, and yes, I'm repeating myself, and the reason I'm repeating myself is because this is very, very serious, and it's going to leave me no choice but to bring a suit against the city. And I don't want to do that, but that's what's going to end up happening.
Actually, I think Vice Chair Shibata wanted to, did you want to say something? No, okay, then I'll go to Commissioner.
I'm hearing that your applicant didn't know about what I call it objections, because it is objections, or an objection, the one after 27. If you're saying that your applicant never knew about this, the way we got this submission, it's an exhibit and it's attached to a letter to us, and I believe it was part of a submission in the proceeding before us back in 2015, 16, 17. The letter actually is dated May 4th, 2016, and it was addressed to the board. And if this was part of a submission to the board, the applicant back then should have got a copy of that submission and looked at it and understood it and built his argument back then.
Commissioner Shetta, the submission that was made by the DOB to you now has language in it that says all of the objections were satisfied.
Well, no.
And they enumerate the number of objections. This one was never enumerated as an objection. And even if it had, it was crystal clear from DOB. They said all objections were satisfied. Every one. That's what we're relying on.
I'm looking at the audit sheet from page 1 onwards. I'm looking at audit number 4, which says arrangement in floor layout of the majority of the units in cellar, first floor, and rear portion of the second floor building labeled quote unquote medical offices are not consistent with the design and arrangements of medical offices, but are rather consistent with the use of a single room occupancy residential use. The creation of single room occupancies is contrary to HMC section 272077 revised. I can't see the fine print 52114 under, I can't read the whole thing. It becomes a little fuzzy. Still is being proposed. It's still being proposed. It has not been reviewed or anything. And it says, okay to be used as medical office. That's the sign off dated 7/22/14. Then 4.1 ZR 2212. It says, since the floor layout is consistent with SROs, the occupancies in cellar, first floor, and rear portion of second floor building is categorized as a residential use per 2212 ZR. Amend the zoning analysis to indicate increase in residential floor area. See revised plan to be used as medical office 7/22/14. So I'm not sure what I'm missing here, because all of this is to revert back all these illegal SROs residential use to medical use. And approve elevation, mechanical opening, erector and spring exit doors. Now, these are all fire exit related things. Then submit the following items, specify the plan and the paperwork, use group 4 being proposed ZR 2214. Ambulatory layout, that's what's handwritten. And that was resolved in 5/21/14. Then provide demolition application. I think this is for the back portion of the building. Yeah, I have to say, there may have been verbal discussions or other documents that you have. Those we never got any evidence of, so we have to go by.
No, there was submissions, Madam Chair, that were from DOB saying, submitted to you in this proceeding, saying to you that all of the objections were satisfied, all of them. I mean, that's a matter of record in this matter and in the prior proceeding. There's no dispute about that.
But just, excuse me, just as a matter of clarity, from what I understand, the reference job number that this audit pertains to is the original 2004 Alt-1 application under which the CO was issued, which is for medical office use, not for residential use on the subject floors.
Right.
So the applicability of Appendix G is obviously different if the use is residential. We're talking about the original 2004 application, not the 2011 change of use application, correct?
No, we are talking about the 2011 application as well. It was on the basis of those plans that we were going forward to legalize this.
The audit specifically. The audit is for the 2004 application, which is for
No, the audit is for the plans that were submitted to legalize this. That's my understanding. That's the way it's always been, that the plans that were submitted were being reviewed. There were a variety of objections that were made, and then the objections were satisfied as shown in the plans that were submitted.
The point I'm trying to make is that the job that is referenced at the top of the audit form is the original 2004 job, which proposes community facility use on the lower floors.
Commissioner, I'm not disputing that with you. What I'm saying is that the whole proceeding in the prior BSA proceeding was because, and no one disputes it, there had been an illegal use of those premises, and there needed to be a whole variety of corrections that were made. The applicant submitted plans. They were submitted before the change in the flood map. They contained a whole variety of things that were going to be happening. They were reviewed by DOB. There was a detailed audit of all of that, and it was as a result of that detailed audit, which we've been talking about, and the resolution of it, that a representation was made to this board that all of the objections had been satisfied.
My only point.
I would love to hear how DOB responds to that.
And I just want to state for the record, Commissioner Sheta is, I believe, sharing screen of that audit, which states flood zone regulations, new filing.
Yes, and it's not an objection. It's written on there. It is not a numbered objection. And even if it was, there's a statement made later on by the DOB that all objections were satisfied. That's just a matter of record.
It either is an objection or it's not an objection.
I say it's not an objection because it's not listed as a numbered objection. Somebody wrote that in there.
So then you're conceding that the flood zone regulation new filing was not satisfied?
No, I'm conceding that it was not an issue that was ever raised. It was not raised. It wasn't relevant. It was not raised. It was not raised by DOB. Had it been listed as an objection, it would have been addressed and we would have discussed it and figured out something. But DOB never said that that was an objection, and they did after this board issued its approval, directing them to issue the building permits that had been sought, that were the basis for the entire review previously.
Can I just say something? When I look at that, it says to me flood zone regulations, new filing. At that point, I would think DOB would be saying, all right, we're going to table this because this is going to be handled in a new filing.
Right.
Now, to the remaining objections that need to be satisfied. That's how I believe DOB looked at it. So it doesn't mean that they dismissed it as if it wasn't an issue. And once we say resolved all the objections, we don't have to think about it anymore. I think they were waiting for a new filing, and that was going to lead to examination of that very issue.
And to support that, I
Brown,
want to say that this is an audit of the original 2004 job with community facility proposed in the lower levels, where the flood regulations would obviously be different than for the proposed conversion to residential use. We're talking about an audit of the original 2004 job. So a new filing would be required for a change of use, in which the flood regulations would then be applicable. Yeah.
Which would require a new filing.
Yes, so just to make that very clear, we're talking about, because I think that is a very key point about relying on this document, is to know what this document is actually saying, what it's covering, and it's covering.
Residential use had been proposed at this time. It was not proposed only after this board ruled. So
Mr. Marshall,
I don't know what to say to you. You're trying again to have it both ways. As if we should limit this, but yet we should know. The residential use was there. If they wanted to turn around and make it an objection, they could have said so. They did not.
We're gonna let the chair speak and then we're gonna let the Department of Buildings speak. Thank
I
you.
think Mr. Barshaw, if anybody who is looking at it, these documents to serve the interest in any both ways, I hate to say it's coming from you. It's not coming from us. It's amply clear to us what then the board wanted and what the board was reviewing. I unfortunately do not have, I'm looking at the resolution number, and the certification number always referred to the 2008 code. We were not looking at 2011 because 2011 was not even a document that anybody could weigh in on, since the 2008 certificate of occupancy was in violation. And until the certificate of occupancy of 2008 was cured, DOB couldn't look at 2011. And if the 2000, so there was, it's irrelevant that you may have filed, your client may have filed a 2008-11 document showing a residential use. It couldn't have been done because the 2008 certificate of occupancy was in violation. And that's what had to be cured in order for the board, for DOB to proceed to the next step. And I completely agree with Commissioner Otley Brown and Commissioner Yoon as to what the intent of this audit was and what may have transpired. And honestly, you have not provided any evidence to that effect thus far that supports your argument. So I have to go based on what has been provided. And I think the direction the board had given to DOB was pretty clear, and the focus was to bring the building to comply with 2008. Let's keep the let's keep the residential conversion for a later stage. First, resolve this issue, because without it, even if, let's say, they were to do it in tandem, they couldn't have done it because Appendix G cannot be waived. What was applicable based on this document and couldn't have been waived by DOB at that time. And this, we were never reviewing it for that purpose. The appeals case was the certificate of occupancy, not for an Appendix G.
Not by the board, by the way, back then, nor by the board, neither by DOB nor by the board.
Our focus was purely on 2008, reverting to the original 2008 certificate of occupancy grants. Mr. Schmidt, go ahead.
Thank you, Madam Chair. Madam Chair, I think that you, Commissioner Otley Brown, and Commissioner Yoon actually ended up making all of my points for me. So thank you. What I think that's really at issue here, taking a big picture, is that I think what Mr. Barshaw is relying upon is what amounts to like an oral history or an oral tradition of the prior cases and this current case, right? Unfortunately, we don't have any emails. We don't have any correspondence. I don't think we've got any affidavits about what was or was not discussed at any particular point in time, right? What we've got is an audit sheet, and we've got a couple of letters to the board that don't mention Appendix G, right? And so the question is, to what extent does this undocumented oral history trump or supplement or augment the written records that we have? And I think the trouble for Mr. Barshaw's position is that I think that audit sheet is fairly consistent, right? If you're looking at the 2004 job, and I think that they are based on the all of the discussions about this 2004 job, about whether or not the 2008 CO needs to be revoked. Why would you need to look at the 2011 proposal to know whether or not the 2008 CO needs to be revoked or modified, right? There's no reason to do that. And if you're looking at the 2004 job and the state of play as of 2011, 2012, when that audit started, the objections, several of the objections that we list with numbers relate to the illegal residential conversion of the first floor and the cellar. And the notations that are provided there with dates seem to indicate that as of July of 2014, the understanding between the parties seems to have been that that's going to be converted back to medical offices. And in fact, what actually happened, I believe it was in 2017.
The mezzanines, I believe, were removed. That was another part of the review at that time. I seem to recall that were.
Right. And what seems to have happened in 2017 is that the residential occupants of the cellar and the first floor were evicted. They were taken out. I don't know whether or not those spaces were physically altered in a way to make them into medical offices, at least. But those people who were occupying that occupancy ceased, right? The physical arrangement may have persisted, I don't know. But Sky East knew that they needed to clear those people out. There's no reason for them to clear those people out if the understanding was, well, heck, we're just going to have them move back in, right? That yes, they ought to be there. Of course they ought to be there. We all agree they ought to be there, right? There's no reason to do that. And then what I would also say, as Commissioner Arlie Brown pointed out, is that handwritten note, and again, we don't know precisely what was discussed, but it does say flood zone regulation, new filing. And so if it turns out that what you're going to be doing is modifying the certificate of occupancy, and it turns out there may be an issue with the flood zone, then yeah, that's a new filing that's separate and apart from the 2004 job. For one thing, you'd be modifying the CO that had already been in place at that point for a number of years. I think the idea that Mr. Barshav is dealing with is the idea that by opening up a BSA case, right, that you suddenly get carte blanche to do whatever it is that you want to do. I don't think that works, right? That if the whole point is whether or not that 2008 CO as granted should have been granted or should be modified, right? There's certainly nothing in the revised resolution that says, hey, yes, you know what? We want Sky East to be able to do this residential conversion. So I think that if we're looking at the documents, I think the documents all basically reinforce one another. They interrelace and they fit together in a very, I think, fairly coherent way. And I wasn't present at that time. I wasn't handling that case. I don't know what Andrew Wallace may or may not have said, right? What I do know is that we didn't have the legal authority to vary Appendix G. Any architect or engineer or attorney working with Sky East would have known that we didn't have the authority to alter, to vary Appendix G. That only the board had that authority, and they did not use that authority in the revised resolution.
Any questions or clarification?
Do you need my screen?
Hmm?
Do you need my screen anymore?
No, thank you. Okay. Should we go to the public?
The case that we're discussing is calendar number 2022-44A, 638 East 11th Street, Manhattan. If you would like to provide public testimony on this application, you may join the Zoom webinar. The webinar ID is 854-2216-5319, passcode 082330. You may press *9 to raise your hand if you would like to speak, and *6 to unmute. If you may also join in via the telephone, please dial 646-558-8656 or 888-475-4499. you may enter the same webinar ID I just listed and then press pound.
Mr. Barshaw, do you have any final statement to make?
The only statement that I would make is that I believe that the objections that are being pointed to as being resolved back in 2014 were relating to the rear part of the property. And that's what's being referred to, and that has never changed. So what we're talking about here are the changes that need to be made to the front building in order to be able to cause it to address the concerns that had been raised about second means of egress and so forth, all of which have been shown forever on these plans as amendments to the plans that were issued and approved back in 2004. The firm should never be an issue. These should have been approved and would have been approved, and DOB concedes this a long time ago had they not unlawfully delayed this process by saying that they couldn't issue the approvals. The only reason that Appendix G comes into play is because we moved past 2013 and 2014, and it never should have happened that way. There were applications that were submitted beforehand. So that's putting aside all of the other arguments that are being made. So my point at the end of the day is that all that was being discussed here about residential, the impact on the front building was to legalize that, to deal with the issues that had been raised and had been raised by this board in terms of bringing everything into compliance. I don't want to keep repeating myself on the prior points, so I'm just going to let those go.
Thank you.
I think Department of Building wants something to say.
Oh, Department of Buildings. Yes, Mr. Schmidt.
Members of the board and Mr. Barshaw, one thing, I think I mentioned this the last time I was here in person. I know that I didn't put it in my written submissions, and I wish that I had. There's one wrinkle here that I want Mr. Barshaw and his client to be aware of, right? My understanding about that original 2004 certificate of occupancy and the original plans, my understanding was that this was supposed to be a building where the first floor and the cellar were going to be, at least originally were pitched as community facilities. And my understanding is that that was done in order to get a zoning bonus. I don't know if that's true, but if it was, right? And this, I'm bringing this up only because I want everyone to be on notice of this as a potential issue in the ongoing saga of this case. And maybe I ought to put something in writing later on. If those community facilities are removed, I don't know what, if anything, would happen to that zoning bonus if there was such a thing. All I know is that's been an issue that's been on my mind intermittently. I want to make sure that the board's aware of it. I want to make sure that Mr. Barshaw's aware of it. I don't know that we get there. If it turns out that this thing, if Appendix G does apply and they can't get the permit and they can't raise this up, I don't know that matters. But that's a wrinkle on this that we haven't really explored, and I just want to note that it's there.
I'm just going to quickly look at Zola for this. I believe the zoning district is R8B, and the R8B, prior to that, it was zoned R72, and I don't know when the zoning changed from R72 to R8B. When it was R72, there was a disparity between the residential FAR and the community facility FAR. I think the residential FAR would have been 3.44 and the community would have been 6 point something FAR. However, I don't know when the rezoning happened from R72 to R8B. When it did get rezoned to R8B, the FAR for community facility and the residential was same. It was 4 FAR. Okay. So if the 2004 application was based on an R72, it started with that. And then that community facility FAR was needed to be able to go beyond the 3.44 FAR, because I think the building is over 3.44 FAR as it stands today. Then then yes, I think your point is well taken, is that then having that additional community facility floor area in the cellar and the first floor would have bumped up the FAR to make it legal. And however, the zoning changed.
Okay.
So zoning, if the zoning changed between that midway to 2004 to 2008, I don't know the exact
Yeah.
time period, I'm speculating a little bit. Then 4 FAR would have worked. So having that community facility wouldn't have mattered. They could have
Okay.
had residential use in the cellar. But to your point, the certificate of occupancy was valid in 2008, still showed it as community facility use in the basement and on the ground floor and not the other way around.
I only wanted to raise it, not because I think it matters to this case, but because there's an implication that because DOB was silent about something that we were therefore approving. And I just wanted, that floated into my mind a couple times in this case, and I just wanted.
No, you raised it at the last hearing and
Yeah.
I thought, and it's ringing up, and I think that may have been the change that happened because this site did undergo a lot of changes
Yep.
as it was being contemplated for from demolition on the way to the Alt One, and this may have been one of those situations. So I'm not sure, but right now R8B allows 4 FAR, and I think they are within the 4 FAR with the use that's there.
I hope so, because anything that makes my life simpler is a
Right.
good thing.
If not, that's another.
If not, we'll have another notice of violation.
Yes. Thank you all.
All right.
Madam Chair. Madam Chair, this is Carlo. I just wanted to just for clarity, if the board, I don't know if the board's closing it, but if there was a schedule going to be set for both parties to provide like a summary submission?
I don't know if you want to provide any summary submission. I think we have a very thorough, I leave it up to both of you, but it should be just a summary of what has been stated. No new evidence. It's what has been stated so far, just summarizing it, no more than 5 pages, I would say. And it should be a simultaneous submission, if anything.
That's fine.
I don't know about you, Mr. Barshop. I feel I've said everything that I need to say.
I'll put in a summary submission. I have no problems with that. Make it clear for the board exactly what we're saying.
Department of Buildings does not have to submit anything.
Okay.
That's fine with me.
Okay. All righty. All right, then I make a motion to close.
Madam Chair, just before you close, what date would you want that submission by?
Once we decide the date of the decision, it should be done at least 3 weeks prior to that.
Okay.
So once we schedule that, but please do not add any exhibits. It's just everything included should be no more than 5 pages.
Right.
Okay.
This time you want me to repeat myself.
Yeah.
It's okay.
No more than 5 pages. All right, motion to close.
Chair Chanda?
Aye.
Vice Chair Shabeta?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Yoon? So calendar number 2022-44A is closed. And calendar number 2023-43A remains open and is adjourned.
Yes. Okay. Thank you, Mr. Barshaw. Thank you, Mr. Schmidt. And again, just for DOB, if after receiving that letter, if DOB wishes to, you're limited to the same constraint of no
Understood.
more than 5 pages, everything included.
Absolutely understood. Thank you.
Okay. Okay.
This concludes the public hearing for March 11th, 2024.
Thank you very much. We'll resume tomorrow with the review and.
Are you going to set a calendar for this?
Yes, we will contact you. Actually,
Okay.
before
Fair
we
enough.
go, there are 4 people. One of them is from DOB, so, but John Bailey, our FDNY liaison, but there are 2 other names in waiting room, now that I notice it, do we see the attendees? I'm not sure if they're members of the public who want to
Field
speak.
and Leslie Peterson in the waiting room. If your case was called and you missed it today, please feel free to submit your comments to submit@bsa.nyc.gov. Otherwise, please check the board's public hearing calendar.
We do have items scheduled for hearing tomorrow. So please refer to our calendar, and if your item is being scheduled, is to be heard tomorrow, please log in accordingly.
Okay, everyone, thank you very much. This concludes. We will resume tomorrow morning at 10 a.m. with the review session and public hearing for March 12th. Thank you, everyone. Have a